With all the tasks and responsibilities involved in running a medically based company, including raising funds, marketing your product, selling your product, complying with all the myriad regulations, I imagine many of you also would like to devote some time to actually developing your product, to seeing how to make it better, to seeing how to make the new ones work. I believe in your type of business, it is quite rare to wake up in the morning, have a revolutionary new idea, call a factory, tell them what to make over the phone, and then call the distributors, tell them to place orders. All this without even testing your product. Of course, in almost every situation, you need to test your product. Certainly in the beginning, you'll see something that does not work quite right, or maybe not even at all. And often this testing takes a long time. In anticipation of having a great product on the market, you also anticipate your competitors wanting to copy you, so you will apply for a patent. You know that you need to get the patent application filed before you introduce your invention to the public. Or at least in the US, make sure you file your patent application within a year after you've shown your invention in public. However, you have a problem for certain types of inventions. Some inventions practically have to be tested in public, and they have to be tested for longer than a year. Imagine a special garment or accessory for a pregnant woman to wear during the entire pregnancy and the 6 months afterwards while she's nursing her baby. You want to test and refine your invention as much as possible, and you can't expect her to stay in your laboratory all that time. You want to know how your invention works when she's conducting her normal daily activities, interacting with the family, going to work, going to the stores, going to the ball games, the concerts, everything in a normal lifetime. That's what you want to see. So what are you going to do? Well, you can't file a patent application yet because you don't know enough about your application to describe it adequately. You have to conduct experiments to know that. And you have to do it in public, but won't that destroy your chances of getting a patent if what you do in public takes more than a year? Good afternoon, everybody. I'm Joe Felber. I'm a patent attorney, and I want to tell you how to deal with situations like this. I'll teach you a little about patent law so you can develop good business habits. I must remind you, this is a lecture and not a private attorney-client conference. Therefore, the tips I give now are not legal advice based on an attorney-client privilege. I'm going to start with a story about someone named Steve, who worked in a boat dealership repairing engines, such as this one here. Now I'll show you what it looks like in the eyes of a patent attorney. I'm going to zoom into this section right here called the bell housing. Here you see two chambers, an upper chamber for the drive shaft gimbal, it must be dry, must stay dry, and a lower chamber for the cooling water, which obviously is not dry. There's a gear shaft here you see in the lower chamber but extends to the upper chamber, which means there needs to be this nice good seal here in the thin wall between the chambers if we're going to keep the upper chamber dry. We'll zoom into this area. And here you see the invention. The invention is a seal, like what I just showed we needed. Here's what happened. Stephen Lell worked repairing boats in Florida at a boat dealership. Some of the engines he repaired were produced by Brunswick Corporation. He noticed that the seals needed replacement occasionally, but after every time he replaced the seals, they didn't hold up as long as the original seals did. He got to thinking about how to make a better seal, and he designed a seal, and he built it. He built 6 prototypes. He put one on his boat in 1986 and distributed other 5 to other people. He must have been happy with how well the seals were holding up, well, at least on his own boat, because he applied for a patent in 1988. Those of you doing the math will notice he applied for a patent more than a year after he distributed his prototypes of the seal. He received the patent, and then later Brunswick Corporation found out about it and decided to design its own seal. Brunswick also made the seal, marketed it in a way that Steve thought Brunswick was infringing his patent. So he sued Brunswick Corporation. When someone gets sued for patent infringement, he'll want his patent attorney to do whatever it takes to get him to avoid a liability. And one common way is to tell the court, my client cannot be liable for patent infringement because this patent is not valid. You can't do that for every patent because some patents are valid, and you have to give a reason. There are quite a few ways to invalidate a patent, and you can guess which way Brunswick chose. Brunswick said that the prototypes that Steve built and distributed more than a year before applying for the patent were a public use, and accordingly the patent should never have been issued. Well, Brunswick's argument did not convince the jury because the jury awarded Steve a verdict of $1.5 million. That's quite a good verdict for someone who works repairing boats. Well, Brunswick did what people usually do in situations like that. They appealed. Appeals for patent cases in the United States go to a special court called the Court of Appeals for the Federal Circuit. Last I counted, there were about 16 judges at that court, but they don't hear every case. A panel is formed of 3 judges, and they're chosen at random. When you choose to appeal, you cannot choose who they are going to be. You have to take what's given. And the decision of that court, a 2-1, not an unanimous decision, was to vacate the jury verdict. So Steve asked for a rehearing in bank, whatever. The request was denied, but other judges wrote reasons why. A lot of them would have done otherwise. My reading of the case is that it could have easily gone the other way if there had been a different set of 3 judges deciding the appeal. Or maybe even if only one of the judges were different. It's a close case. There's not a simple way to say this should have been in place, or the patent should never have issued. I want to explain to you what the court what considers when they decide whether to rule that a patent like this should never have been issued. So first I will discuss the relevant law. We've actually discussed this in some form already. From Congress, you may not receive a patent on your invention if your invention was in public use more than 1 year before the filing date. However, from the courts, if the use in public was totally experimental, it does not count as a type of public use that could prevent you from receiving a patent or be the basis of invalidating your patent if you ever did receive it. Note that just because you receive a patent from the patent office doesn't mean that it cannot be invalidated later. The examiners at the Patent and Trademark Office are so busy and they can't know about everything that's gone on. I do not believe any examiner lived in Florida in 1986, 1987. So based on what the examiner knew, the examiner allowed the case. For Sam's case, the legal question for the courts was whether his use or distribution of the prototypes was experimental or not. If it was experimental, it does not count as public use and he can keep his patent. If it was not totally experimental, it will be public use and his patent will be invalidated. For the court to determine that, it looked at how courts have been determining things like this in the past. And a classic case has to do with a patent on a road surface. This is an old case from over 130 years, but it's still good law. Sam Nicholson designed a new road, and he set up a prototype of some respect. a strip of a little over 20 meters, and he tested it for 6 years. 6 years! Back then, a patent applicant was allowed to wait 2 years instead of 1 year, but this was 6 years. But you have to test the road for a long time if you want to know if it's going to hold up or how well it's going to hold up over a long time. The court, in this case, the Supreme Court, decided that, they affirmed that a long period, perhaps years, may be necessary to enable an inventor to see if the invention is durable. The court said that a proper experiment on a street pavement must be done in public. You might be thinking, well, you could have your own private property and do this in an area where no one's going to see it. It doesn't have to be in public, does it? I mean, I thought that myself, but it doesn't matter what I think. It doesn't matter what you might think. It matters what the court thinks. And the court thought that it was necessary enough. It had to be done in public. And this is the law. And this is good news if you have a patent on a road surface, or you've done or something similar in public. Also, the court considered testimony of a toll booth collector. This was a toll road. The person collecting money was able to see the inventor there. He testified that the inventor tested the street surface almost daily with his cane hitting the surface. He was asking this toll booth collector, how did it sound? Was there enough, the horses hitting it? Did it work out okay? So the court said this was a legitimate experiment, nothing more. He can keep his patent. Unlike this case of a medical device, hopefully not yours, this is an intraocular lens. In this case, the inventor implanted the lens in humans' eyes, in 8 lenses in the eyes, before the critical date, which means more than 1 year before applying for a patent. He saw someone he thought was infringing his patent. He sued them. The infringer said, as before, the patent is not valid because the inventor already implanted 8 lenses long before he applied for a patent. So the inventor said what you would expect. He said that was just experimental. However, there was deposition testimony before the trial. The inventor said that he didn't conduct experiments. He didn't need to test it because he was pretty sure that those lenses were going to work right away. He also believed, as he said in the testimony, his lenses were not significantly different from another model that he had implanted on hundreds of occasions in the past. He may have gotten out of some other trouble by making this argument, but it didn't help convince the court that his earlier use was just experimental. He couldn't keep his patent. It was invalidated. So now we're back here with the case for Steve. And I'll go through this section quickly to give more time at the end. The court balances different facts. There's factors to consider whether what has happened was really an experimental use or not. And if the findings weigh more in favor of experimental use, the patent holder can keep the patent. Otherwise, the patent is invalidated. First factor, compensation. Steve did not charge any money for his prototypes. Well, that's good. That looks like an experiment. You wouldn't expect people to have to pay if they're doing you a favor. Another issue is regarding a secrecy obligation. Well, in this case, Steve did not swear to people to secrecy. The court felt that this did not look like it was an experiment if you were going to allow people to see your invention, not testify. So move along quickly right here. There are more factors. One is for continuing inspection. You pass out your prototype. You want to ask later, how is it? How's it working? May I see it? Steve didn't do that. So it doesn't look like an experiment there. And perhaps the most important is the issue of control. Did Steve tell people how to use it, what to do with it, what not to do? No, there was no control. In one case, somebody sold the boat that had one of the seals, and the and he doesn't know where it happens. So that doesn't sound like that's an experiment. Maybe what Steve did with his own seal was an experiment, but there were 5 other seals. 3 he gave to friends. 1 went on the boat of the dealership owner where he worked. 1 went on a customer's boat. So with all this in mind, the way the factors tipped the balance towards saying this was not an experiment, the patent is invalid. So you're wondering what to do. I'll tell you what I would do to protect my invention, and it's fictitious. Any similarity to this invention with a real invention is totally coincidental. It's a hearing aid, and this is the part that goes inside the ear. It has the electronics for amplifying the sounds and deciding which sounds amplified and which not. They don't all get amplified the same amount. There are the receiving means, sound receiving means, and to keep the hearing aid from falling out of the ear, there are retaining means. I see some of you there are smiling, you're laughing. Okay, I'm not an inventor, I'm an attorney. You are the inventors, you do what you do best, I do what I do, we work together as a team. There's one more element, and that is a computer program running on either a PC or a smartphone, and it's where you tell the hearing aid which sounds to amplify, which not. Suppose you want to take a nap and you don't want to hear your 12-year-old kid playing. So from the hours of 1 to 12, you go to the PC, you go to sounds, you go to kids, you go to 12-year-olds, it's the different menus you pick. Yes, and then for the time from 1 to 12, you set the amplification level low. Okay, now suppose you want to hear your baby. If your baby makes a noise, you go to the same menus, but for baby, infant, and you have during that same time period an amplification level higher. You have a particular voice you want to hear or you don't want to hear. Your bosses you want to hear when the boss is around the corner, or you're on a bus and you don't want to hear this one person talking so much. You can set the amplification levels just the way you want it. You have a smartphone. Smartphones are great. People carry them anyway. You don't need a special hardware, additional hardware for my invention. You just go record the voice when the person's not looking, and then you set the amplification levels the way you want it. And I am so psyched about my invention. I think it's going to be good, but I just don't know if it's going to work soon enough. Is it going to be ready for me to apply for a patent within a year of when I first start testing it? And I have to test it in public because I want the person to have it all the time, conducting normal activities, not just my simulated activities in a laboratory. So this is what you should do also. I am going to make sure anytime my test hearing aids prototypes go out in public that it's going to be so clear that this is an experiment, nothing else. So anyone trying to invalidate my patent later will just have to come up with another way. They're going to say, I'm not going to say it was an experimental use. Some of you might be saying, I don't plan to sue anyone. I don't care. But still, you want to have your patent strong enough so that if it were to be used against anyone, it would not be invalidated for an experimental use in public. Okay. So what I'm going to do is I'm going to have a special experimentation policy. It's going to be formally documented. It's going to be in writing. Everyone in my company who does experimenting, at least the people in the public, is going to know about it. The support staff is going to know where to find the policy on the servers. And I just want this to be available in case someone is trying to invalidate my patent. They look, they see, oh look, this guy was really organized. He knew what he was doing. And it's going to set out the plan of use for every experiment we do. I mean, you do that anyway. You write down what your plans are, so it's not really that much extra work. It's going to specify how the experiment's going to be run with different steps, what you're going to look for. It will specify continued examination of the prototypes. I'm not just going to give my hearing aid to other people and say, here you go. Let me know what you think afterwards. If it's fine, tell me anything you want to know. No, I'm going to set the time It's going to be in writing at a date, every month, every week, however is appropriate. And how we're going to do that, either a phone call or they're going to come in, maybe an email, or maybe there's going to be a web device, a website where they fill out a survey, SurveyMonkey, and they tell what needs to be done, what I need to hear. It will clearly be secret. They will know it's confidential. When they unwrap the package and they see my hearing aid, the seat put in their ear is going to be marked confidential. You saw the confidential I put on the screen before showing you my invention. It'll be like that. The computer applications, either on the smartphone or on the computer, on the PC, will say confidential when it first comes up. You will need a password to get into it. Confidential, unauthorized personnel are prohibited from further access, etc. All that. I'm not going to sell my hearing aids to the people who are coming in to help me develop it, help me do it better. I'm going to find a budget where I'm going to provide it. Maybe this seems obvious to you, but think about it. You might say they're coming in anyway for an extra hearing aid. It costs, just hypothetically, $1,000 for a new hearing aid. I'm only going to charge them for the conventional part. The extra part I did to it is cost me $500 to add to it. That I won't pay. That I will pay. I won't charge them. Well, I wouldn't take a chance. Come on. You don't have to do everything I say right here. You might be okay without some of the things, the formal documentation of your policy, for example. However, I'm doing things because I want to stack the odds in my favor. I want to do as much as possible because I don't know which judge is going to look at this later. I want something to appeal to everyone. If it's not that much extra effort, I'm going to do it. As far as the sale of the prototypes, the patent you saw for the road surface was tested on a toll road, and the inventor, Sam Nicholson, was a partial owner of the road. He was making money when people would go by, but the Supreme Court ruled that that was just an incidental use. He did not have that surface anywhere else other than that one small strip in one area that he tested all the time. So you could take your chances about charging a small price for your prototypes. I'm just advising against it. That's not what I'm going to do. In fact, I think I would try to pay the people that are coming in. They're providing a service to me, giving me their opinion of the product, so it makes sense to pay them. And it certainly, I believe, looks strong that this is an experiment. I admit that this is an original thought. In all the court cases I've looked at, I haven't seen where that was done and that was a factor influencing the court favorably. However, it makes sense to me. Why else would you pay someone to use your product? It's not advertising because you are forbidding them from telling you people what you're doing. I will maintain control. I will tell them what they can do, what they cannot do with the prototypes. In other words, what they do is they use it for themselves. They do not give it to their friends. Maybe in a hearing aid, they may not be likely to do it. But you get the idea. Can't give it to anyone else. You don't even talk about it with anyone else. After the end of the testing, it comes back to me. It is mine. I will tell them in advance when that is. If for some reason we want to extend the experiment, we can always document that. Right? We're extending it, tell them, and all that. But otherwise, it comes back to me. The PC applications, or the computer applications, will be set to deactivate at the end date. If I was extending them, my programmers will extend the operability. Okay. At this point, I asked if there were going to be any questions, but since this is a simulated lecture, I know there won't be any questions. So I will tell you one last thought. You remember in the beginning when I was showing where the seal goes on the engine, how most of the general public won't see it. You had to go inside the bell housing, and then you see an upper and lower chamber, and in between that is where the seal goes. The general public doesn't see that, and you wonder if that's public. Well, the use of it is public. If you're cruising on the waterway, that's in public. It's a public use. It doesn't matter if the public could really look at the invention itself and know what it's all about. I'm wearing a mesh right now from a hernia operation a couple years ago. At least I think I am. I was not conscious, but that's what they tell me. You can't see it, but I am using it in public. So I am out of time, and thank you very much.